Yes, I salute you all. Thanks for listening and thanks for watching. So basically today, we are under land law 2, and the topic of emphasis that we are going to look at leases. Basically under land law 2, we are going to look at leases basically, and section actually leases. They are provided as you hear the word lease. For a lease is like giving, as you shall see the element, but in the element that you give ownership. Actually, you give someone to use your land. You don't give him or her ownership, but you let him to use your land for a certain period of time. So basically, under Section 3, subsection 5 of the Land Act provides for the creation of a lease. It may be created by a contract, either the parties mutually agree to the creation of the lease. It may be also created by an operation of law. For example, section 41, subsection 3 of the Land Act provides that non-citizen can only be granted a lease of 99 years. You get. Whereas citizens, when you read section 41, subsection 2 provides that non-citizens can have a lease of 5 years and above. A lease that's from 5 years and above. Basically, note that in mind. And when relate to section 101 of the RTA, provides for a number of implied, actually from 101 to 105 of the RTA, provides for number of implied covenants between a lessor and a leasee. Basically, a lease binds parties to it as well as successors in the title of the parties. You get. This means that even though actually your father leases land, even though he passes on, you the successor, you are bound by that lease. You must abide by it and follow it. You get. So note that in mind. And the lease, basically, lease tenure is defined as a form of tenure whereby a person called the lessor grants to another a right of exclusive possession of land for usually but not necessarily a period defined directly or indirectly by reference to a specific date of commencement and a specific date of ending, basically. So we go to the classification of leases, some of the classification of leases. Under the classification of leases, we have a fixed term lease. Fixed term lease is the one whose duration is fixed by the parties at the commencement of the lease. Secondly, we have a periodic lease. A periodic lease, this is one which continuously renews from one term to another. Periodically, you renew. That if it ends, you renew like that. That is a periodical lease, whereby even a periodical lease terminates by proper notice being served by either of the parties. You get. For example, actually, this was also portrayed in the case of Prudential Assurance Company versus London Residuary. Okay, that case provides what a periodical lease means. Then we have another category or a classification of lease, a tenancy at will. A tenancy of the will is defined in the case of Bweya, B-W-E-Y-A, Bweya Steel Works Limited versus National Insurance Corporation. To mean a person who enters into possession of the landlord's premises as a tenant without specification of the terms of the tenancy and conditions, basically. Then at last we have a tenancy at sufferance. Tenancy at sufferance, it is defined in the case of Hassan versus Muchivi. In the case of Hassan versus Muchivi, realize that it stated that a tenancy at sufferance is implied where a former tenant remains in possession of a rented premises after the expiry of the period fixed by the owner. So you are there at the mercy of the owner. The lease was ending at 6 years. The 6 years lapsed, but you are still on land. So you are a tenant at sufferance, because anytime the land says, please vacate, your term ended long time ago. You get. So basically that is a tenant at what? At sufferance. Then when to go further, we have the essentials of a lease. Essentials, they are like the conditions of a lease. You get the first one, exclusive possession. You get exclusive. This connotes that non-interference from anybody, including the landlord, the one who gave you land. You get that is exclusive possession. You own land exclusively. You get from even the one who gave it to you. When you read section 3 of the Land Act, defines a lease code as a tenant under which a landlord grants or is deemed to have granted the tenant or a lessee exclusive what? Exclusive possession in that essence. You get, and this was portrayed in the case of Desai. Desai is Desai. Desai versus Copper. Under this case, it was stated that if the landlord retains general control over the rented premises, it is strongly believed that there is an interference with the right of what? Exclusive possession. The control basically, the control can be, there's a case of City Council of Kampala versus Muchimbi. City Council of Kampala, the plaintiff leased a certain premises to the defendant without a right to sublet, without their consent. The defendant allowed some hairdressers to use the premises, paying the daily fee. So the plaintiff sought to terminate the lease on ground that the defendant parted with the possession and had breached the tenant's agreement. At the end of the day, court held that that was not a lease. There was no right of exclusive possession. Basically, there was a subject of a control. If you don't give me a right to sublet, which means I don't have the right to exclusive possession, basically. Note that in mind. One of the elements, exclusive possession, essentials of the lease. Secondly, certainty of duration. The duration must be certain. You get, however much the act, sometimes it is doesn't give it the clear notion. Because when you read the act, okay, the act for it says that the time can be, it is not necessary that it has to be certain. But under common law, a lease must be for a defined, under common law, a lease must be at a defined duration, i.e. having a specific date of commencement and also having a specific date of ending. And that was emphasized in the case of Prudential Company Limited versus Uganda Residuary. You get, it was really emphasized in that case. But the act for it provides the under section 3, subsection 5C, I think C there, provides that a lease is usually but not necessarily for a period defined directly or indirectly by reference to a specific date of commencement and a specific date of what? Ending. You get, so note that in mind. There is a backup case of Lance versus Chandler. Lance is LSCA versus Chandler. CHANTLER, Chandler, whereby the plaintiff during the Second World War sublet a house to a defendant for a period of the war. The court held that the duration was uncertain. How can you tell me for the period of the war? We don't know when the war will end. So the court held that the period was uncertain and it could not be a lease, basically. In that essence, it couldn't be a lease. You get? So basically, those are the two essentials of a lease. Then when you go to termination of a lease, under termination of a lease, first of all, the first one is expiry. When the time expires, the lease goes back to the owner. He's terminated. Secondly, notice. For a fixed term lease, there may be provisions of termination of the lease upon giving notice. Such provision must be complied with, basically. Once they give you notice, must be given to lessor, and actually the lessor the notice must be given to him direct. You get, we have the case of Lennon, Leno, Lennon versus London, Ladoem, London, that gives that element that here they gave a notice, the property belonged to the wife, and the husband gave notice of termination to the lessee. The lease contested and court held that the notice was illegitimate since the husband had no authority to give notice on behalf of his wife. So note that in mind. Then we have notice, we have expiry, we have forfeiture. Forfeiture is like you end something, you end it something. This is a situation where the landlord is entitled to re-enter the granted promises and put an end to the lease where there has been the tenant conditions on the lease basically. That is forfeiture. Where there is a fundamental breach of a term or condition on the lease agreement, it leads to forfeiture. Basically, it leads to forfeiture. Then we have surrender as another way of terminating of the lease. You have surrender provided under section 107 of the Registration of Titles Act. Surrender, this is where before the expiry of the leasee surrenders his lease to the landlord. Surrender may be express agreement, operation of law, or under statutory provision, as you have seen under the RTA. You surrender, you say, I no longer want the lease. I've given it back to you. That is to surrender. Then another form of termination of a lease, we have merger. Merger, M-E-R-G-E-R. So merger, this occurs where the tenant, in addition to holding his leasehold interest, acquires a revisionary interest as well. Remember, a reversionary interest is on the person that gave you a lease. Is on the leaser. So here, this is where a tenant, a leasee, acquires the reversionary interest as well, which was supposed to be on the leaser. So in this essence, this is where before when the lease is continuing, whereby the registered proprietor has leased land to you for a period like for 25 years. Before the lapse of the lease, he agrees to sell that land to you. So when he sells that his interest in that land to you, in this case, the leasehold interest is terminated by merger. You own the lease, but you have sold that land to you. So the lease is terminated by merger. Lastly, you have frustration. The lease agreement can be terminated under frustration. Frustration deals many things whereby the land has been destroyed by earthquakes, floods, among others. As you hear the word frustration, it must not be in the making of both parties. It must come naturally. So bear that in mind. And just know also another thing after termination, just know that some of the obligations, we have seen that we have the right of a lessor has the right to re-enter the leased land. Following section 102 of the RTA. Has the right to re-enter the leased land in case of breach of the what? Of a condition in lease. Then we also have that the leasee is entitled to quiet enjoyment. The leasee is entitled to quiet enjoyment. Opinia versus Mukasa gives that element. Quiet enjoyment, that it gives that element of exclusive possession, as we show the essentials of what? Of the lease. Exclusive possession. Then also the leasee, the leasee must pay rent, basically. Section 101A must pay rent, basically. Then tentative repair, section 101B, it must be in that condition, basically. Other than that, that's the sum that I can talk about a lease. Leases in landlord 2, basically. But other than that, thank you for listening and thank you for watching. Stay blessed and good luck.